Welcome to People, Places, Planet Pod, the official podcast of the Environmental Law Institute, a nonprofit, nonpartisan organization working to ensure a healthy environment, prosperous economies, and vibrant communities founded on the rule of law.
Welcome to this week's episode of People, Places, Planet Pod. My name is Dominic Chicatano, and I'm a research associate here at the Environmental Law Institute. Today's episode is another installment of a new oral history project and podcast series entitled The General Counsel's Opinions, Conversations with the Attorneys Who Have Led EPA's Office of General Counsel. As the Environmental Protection Agency prepares to celebrate its 50th anniversary in December 2020, this series will document the history of the OGC through conversations with the 12 general counsels who have led the office. ELI would like to thank Alston Bird for supporting the General Counsel's Opinions series. Today I'm here with Kevin Minoli, a current Alston Bird partner who was an attorney in EPA's OGC for 18 years before joining his firm. From January 2017 to January 2018, Kevin had the opportunity to lead the OGC as EPA's acting general counsel. During that time, Kevin says he would often look at the list of general counsels on the EPA's website and wonder what the time leading the office was like for each of them. The General Counsel's Opinions podcast series is a chance for Kevin and all of our listeners to hear firsthand accounts of these experiences. Kevin will be joining us throughout the series, each time for a conversation with a former EPA General Counsel. On today's episode, Kevin speaks with Scott Fulton, who served as General Counsel from August 2009 to January 2013. Scott is president of the Environmental Law Institute. Previously, he was a partner at Beveridge & Diamond, PC, and served in a number of top governmental leadership positions in addition to his time as General Counsel. He teaches international environmental governance as an adjunct professor at George Washington School of Law, is a fellow of the American College of Environmental Lawyers, and a member of the UN Environment's International Advisory Committee on Environmental Justice. Thank you to Kevin and Scott for joining us today.
Thank you for having us. Scott, thanks for joining us. We're in the ELI facilities here, but thank you for coming in just the same.
Sure thing. Kevin, always good to see you.
Good to see you as well. In these conversations, we are trying to give people a little insight into what it's like to be the General Counsel of EPA. And you're one of only 12 people who've held that title since the office was made into an independent office. Each one of you got to the position from a different way, in a different way. And so we like to start by asking, what led you to becoming the General Counsel of EPA?
I would say it was a long progression that really began with a tenure as the Deputy General Counsel, or the Principal Deputy General Counsel during the Clinton administration, that equipped me to later come back to that function of the agency, having done a number of other things in the interim. But that experience helped me understand the basic function and nature of the work of that office, and gave me the confidence that I could do the job at the later point in time in which the invitation to do the job would come. Now, I was a careerist in the federal government, in jobs between the Justice Department and EPA for 26 years before the invitation to take a political appointment emerged. And for me, that happened at the beginning of the Obama administration. I didn't know at the time that I would be asked to be the General Counsel of the agency. I was first asked to be the acting Deputy Administrator of the agency. And this, I think, was a function of some relationships from the Clinton administration that carried forward into the Obama administration. This is something I was more than happy to do, and it was through the course of serving as the acting Deputy Administrator that I, of course, got to know the administrator well, Lisa Jackson, and she was not an administrator who came to town with a lawyer in tow. And as part of my work as the acting deputy, I was trying to find her a general counsel. And the White House at the beginning of an administration has a running list of ideas that they want agency and department principals to consider. So we were getting a stream of suggestions from White House personnel, and Lisa Jackson was not drawn to any of them in particular. So at one point in the process, she looked at me and said, well, why don't you do it? Would you be willing to take this job and convert to a political position? And I, at that point, had already made the calculation in my own mind that I would do anything I was asked to do by the Obama administration, because I was strongly committed to the success of his presidency. So it really wasn't a difficult question for me to ask. And nor was it a question that was challenging from a professional standpoint. At an earlier point in time, the guarantee that flows with a political appointment of ultimately leaving government would have been challenging for me, because I was interested in retiring from the government at some point. But when this invitation came, I was at 26 years, and so I knew by the end of the first term I'd hit the 30-year mark and I could retire. So I told the Obama folks that I was willing to do it, but they should understand that I would be a one-term general counsel. And they said, not to worry, if you last that long, you will have outlasted every general counsel who's ever had the job. So it was on those terms that we proceeded.
Right. Only to be bested by
Yeah.
Avi. Avi just one person later by, I think, about 7 days or so.
Yes, had I known that Avi was going to do that, I would have extended my retirement date by another month and foreclosed that option altogether.
Your transition through your career, you were the one person that I think that rose to the job, having been at EPA for most of their career, sometime at DOJ, but for the long, most recent history before that, at EPA. How was the transition for you from career to political appointee, and what was that like? And did you think that it was more or less challenging because you had been a career person at the agency, or was it what you would imagine it would have been had you come in from the outside?
I would say it was challenging in different ways than I expected, probably. I mean, I thought that because I'd been operating at the senior career level for so many years and had seen the political process from that vantage point and had acted in political positions for fairly extended periods of time, that I knew what the game was. What I discovered was that it was more involved, and there were elements to it that really were out of view to some degree, even for senior career people, that were material and meaningful. And in particular, the relationships with the White House and the Office of White House Counsel, the relationships with the Office of Management and Budget, the arm wrestling that goes on between agencies and departments at the PAS level. A lot of that is probably mercifully out of view for the careerist, but there's some art and craft to being successful in the political ranks. It's a little bit different than the experience in the career ranks. It's certainly not beyond the means of career folks to do, but it is a little different.
And that was, my experience as well throughout the acting period, that there were always going to be conversations that needed to happen amongst the political team, and that were more appropriate to be at that political level, even if I might have held the title acting general counsel. It was a different understanding about the limitations of that role, even as you sat in the chair of the general counsel.
Yeah. It does mean something to be one of the president's people. It it draws you into a series of exchanges that you would just not be privy to, even in circumstances where you've got kind of optimum openness between the career and political ranks. There's still there is a line of separation there that needs to be understood and appreciated.
And that's, that reflects on sort of how it changed, sort of managing up or looking upward. Did you see a similar change to looking at the staff of the career folks that did that relationship change or become more challenging or not for you when you became a political appointee as opposed to senior acting official?
I would say not so much for me. And this is partly because by the time I became a PAS, presidentially appointed Senate confirmed appointee, I had been a fairly senior manager of people and organizations for over 20 years, so I did not see a big difference in the leadership quotient in managing as a senior career leader and managing as a political appointee. I did not feel the need to kind of shift or change my management style or orientation. I felt like the basic leadership principles that I had tried to adhere to along the way were just as relevant in moving the organization in response to the policy agenda of the administration I was serving were equally valid. And so, no, I didn't experience a significant change in that regard.
You referenced a couple of times PAS appointees, the presidentially appointed Senate confirmed appointees. Just for folks who may not be steeped in sort of how EPA is set up and how those positions, how many of them there are about, I think, 10 or so PAS, presidentially appointed Senate confirmed positions at EPA, the administrator, the deputy, the assistant administrator for the major offices, the inspector general. But that's it. And then there's about probably 60 or so more political appointees that don't require the same level of appointment or Senate confirmation. So PAS officials, which the General Counsel is one, is among the top at the agency, certainly in terms of seniority and its relationship with the White House because of that.
And I'd say also authority. I mean, for people on the outside of government, kind of understanding that hierarchy is not easy, but there is, it's unquestionable that the PAS appointees in Washington, D.C. Are superior officials in terms of authority to the non-PAS appointees that are scattered around the agencies and departments. In EPA's case, for example, the regional administrators who are quite authoritative within their region, but when it comes to matters of national interest, national policy, there really isn't any question what the hierarchy is. It's really the PAS folks who are really, in a sense, only one step removed from the president that have that authority.
It was always my sense, and I think that of others, that the Senate confirmation gave a political appointee a little more gravitas, a little more independence or ability to step up and stand up for something that might be different from what the administrator prefers, all within under the understanding that everyone works for the president in that line. Did you feel that was that sense that we had in the career ranks? Is that an accurate sense from your perspective?
Yeah, no, I think that is an accurate sense, and I think the dynamics within the political leadership of an administration reflect that. But it's not all gravitas. There's also some hazards that flow with it. There are commitments that you're asked to make as part of the confirmation process, things that you're encouraged to look into, and that sort of thing. And the confirmation committee, whoever that might be, Environment and Public Works for purposes of EPA and the Senate side, they they view that as a meaningful accountability check, so that if you don't follow through on things you said you're going to do in the confirmation process, they can hold you to account for that. And of course, there's also the assurance that if things go sideways or south in some way for an administration, that that they're going to want to talk to the PAS officials, the ones that they confirmed and see as accountable to the oversight machinery. So the opportunity to appear before Congress and congressional hearings and the like is increases with PAS status.
I do remember well the day that you called my office and offered me the opportunity to manage oversight for EPA, and thought it was a poor choice of words, knowing what I was about to get myself into. But nonetheless,
I'm sure I sugarcoated it. I'm glad you did it.
I'm glad I did too. I learned a lot and built a lot of good relationships that way. Did you have fun in the job?
Yeah, I did. I'd say. And part of this is a function of the headiness at the front end of one of these political appointments. But the first couple of years, first as acting deputy administrator and then as general counsel, which kind of they merge in some ways in my circumstance, because my involvement initially as acting deputy administrator also influenced my presence within the Obama administration EPA. I mean, in some ways, I had some special status as a result of that role that kind of carried through the entire tenure that I had there. But just to give you some examples of the kind of headiness part of the equation, there definitely were opportunities that emerged that had never been available to me before, to go to the White House and do cool White Housey things, and spend time in the Situation Room with the president and the vice president, and really any day with the president is a good day for any of these jobs. At least I was never in a circumstance where I was in trouble with the president, thankfully. I'm sure those are not fun days, but I remember when I was acting deputy administrator, Angela Merkel came to town to give an address to the Joint Chambers of Congress, and so the call went out for the cabinet to appear. Lisa Jackson was out of town. I was the acting deputy administrator, so I was the EPA cabinet member for purposes of this event. So I was part of the kind of gathering of cabinet officials. As I recall, there really were only about half the crowd were legitimate cabinet level appointees. The rest of us were subs. But when it came time for the address to be given, the great doors of the House of Representatives open, and the clerk of the House announces, "And now presenting the President's cabinet," and we marched, and with all of the members of Congress sort of glad handing us on either side of the aisle, and we sat there in that little box, basically where I think the Supreme Court sits during the State of the Union address. Well, is that right? No, I think we were sitting where the cabinet sits. I think the Supreme Court also came to that. We had our moment with Angela Merkel as part of the president's cabinet. So that was fun. Mm-hmm. There were other things that just sort of quirky, interesting things, like so one point Lisa Jackson, as a team building event, had all of her political team go to the bowling alley in the White House, and we went bowling, and it was fun too. I mean, these are just things that most of the American people never get a chance to witness, much less participate in, and they were available to me at that time.
What would you say was your best day if you look back?
maybe the one that I just mentioned, the sort of White House, all fun, no burden experiences. From a programmatic standpoint, a good day for me was when we finished the work on environmental justice legal tools, which I had always seen as a piece of unfinished business for the agency. Had always been frustrated by our difficulty in making progress on that, so I'd kind of taken that on as one of my agenda items as general counsel, and was pleased with how that came out. Was also pleased that the administrator, who was strongly committed to the idea of environmental justice, saw it as such an important contribution. Remains to be seen how well actualized those ideas are or can yet become, but it was a good moment for OGC, some of the best of what that organization can do from my vantage point.
How much did you have the ability to identify priorities like that you wanted to pursue as a general counsel, obviously wanting to get the buy-in of the administrator, but lawyers, we represent clients and we represent them on the issues that they care most about. But did you find that you had the ability to say, this is something that I care a lot about, that I'd like to make a difference on, and make that happen?
This is one of the areas where my functionality as a deputy administrator and my role as general counsel kind of blended a bit. I probably, at least at the front end of the administration, had a little bit more self-determination ability than the typical general counsel might, partly because I was carrying things over from these other jobs. And there also was a time before Michel DePass, the international affairs head, was confirmed, where I was also doing that job. So for the first 6 months or 7 months of the administration, I think I was the acting deputy administrator, the acting general counsel, and the acting head of the international affairs office. So when I started more purely doing the general counsel's job, there were some carryover things from those earlier functions that still informed and influenced what I did. And some of them stayed with me. Like I never stopped doing the work in China, thankfully, because that's work I'm still doing now here at the Environmental Law Institute. But I remember when I first came into OGC, my interest was in trying to fix broken things and get things that weren't working well working better, to solve some intractable problems. And some of those problems we went on to do some things with, some of them relatively well, probably some of them as they ultimately unfolded less well. So I remember, for example, talking about the problem of jurisdictional waters under the Clean Water Act, and my goal that the Obama administration could make a contribution in clarifying the reach of the Clean Water Act. And the Waters of the United States rule was ultimately born of that process. I wasn't there when it came out. It's had some challenges, needless to say, in terms of its durability. But I still think this is the right point of focus for in terms of leadership at EPA to solve the unsolvable or difficult problems. I mean, that's why people are in these positions. None of it is easy. But if the leaders in Washington, D.C. aren't willing or able to take on the big problems of the day, then they're really not leading the country. So, I wanted to be responsive to the problems. Climate change, of course, is another one, and that was a huge investment of time and energy to try to figure out what the right response was on the other side of failed efforts to legislate in this space, and what was the reach of the Clean Air Act, and mechanically how could that really work in the climate space. And those were tough questions. And ultimately, I'm happy with the contributions that we were able to make on that front.
Do you see the big intractable challenges as being solvable? Taking waters of the U.S., for example, with the future of every rule being able to be challenged in the district court, which, is judges all across the country, and the likelihood of one at least setting that one aside every time that there's a new rule. Is there a solution with what we have for tools today? Or is it something that if we're going to solve it, it might need a different statutory provision or approach to get to a different place?
Well, we probably won't know for sure until the Supreme Court gets another shot or two at some of this and helps clarify the mess they made of things with Swank and Rapanos. I mean, part of the problem that we have is a fairly unsuccessful venture into the jurisdictional question by the Supreme Court, which kind of left things confusing and deeply problematic, not just for regulators, but also for the regulated community. So I think there's a small chance that if some of this gets back to the court, we might get a clearer picture, and hopefully one informed by modern understanding of how ecosystems function and how water systems function, so that we're with both eyes open, seeing what we're doing and not doing in terms of effectuating these statutes, in terms of how we see their jurisdictional reach. Ideally, we would be modernizing our legislative legal infrastructure to align with these modern understandings. We would be dealing seriously with the fact that not only is the federal government's authority constrained at this point in dealing with freshwater resources in this country, but half the states in the union have decided to constrain their authority to the same space. There's a theoretical notion that what the federal government can't get to, the states will, but there's also a practical dimension that says, well, the states are choosing not to, and so therefore no one's really doing it. And the fact that we've plateaued in achieving our water quality goals in this country should not surprise us. And the only way to actually get to the place of fishable, swimmable waters across the board, which was the goal of the Clean Water Act, is to re-envision our legal tools in keeping with how ecosystems actually work and function. Something we didn't know quite so clearly 50 years ago, but we know very well now.
So looking backwards again, is there something that stands out that you might have done differently or you wished had gone differently, or a day that was particularly challenging when you look back?
I hope I'll cite the decision correctly, but I think it was UARG versus EPA was the challenge, the so-called tailoring rule under the PSD program. And this was sort of a bad day, good day. It started off as a bad day because the Supreme Court invalidated a significant portion of this rule that we had labored over extensively. And it had embedded in it a really perplexing legal question, which was how to deal with the quantitative thresholds for regulation for PSD pollutants that are set out in that section of the Clean Air Act, which are described as 100 tons, or in some cases 50 tons, as I recall. But when you're dealing with carbon dioxide, these numbers are hard to work with, because 100 tons of CO2 might be generated by a donut shop. So there was a need to figure out a path through that that allowed for CO2 to be seen differently and not subjected to those thresholds. We struggled our way through that, thought we had an articulable and credible path for reconciling all that. That was brought to the Supreme Court. basically, on the strength of a legal conclusion that we had thought not possible, concluded that you could actually have a contextual reading of the Clean Air Act that would allow you to regard what is a pollutant in one section of the Act for meaning something different from what is a pollutant, same term, in another section of the Act. I would say that had we known that such a contextual approach would fly with the court, we undoubtedly would have pursued it. So I really wasn't that distressed by the court's analysis. It was more distressing that we had to start over again for a not insignificant part of the rule. But the initially our chins hit the floor because we thought it was a difficult outcome. It really wasn't until we understood it better that we realized that the core of what we were trying to achieve was actually preserved by the ruling, and the other piece was the one that we had been struggling with, and they had now said there was an answer for we didn't know existed.
It'd be interesting to know if you could rewind time whether the Supreme Court would have adopted that theory had it come from EPA.
Yeah, exactly. If it had been our idea,
just their idea, it's okay.
Who can say?
Right.
Well, I mean, the antagonists in the equation have no doubt argued against it. So it would have, it might have been seen differently by the court just because the advocacy would have shaped up differently around it.
So we've done a lot of reminiscing and looking back, and the last couple of questions I have look towards the future. At some point in the future, there will be a 13th person to serve in the role and be tapped to lead the Office of General Counsel as a General Counsel. What advice would you give to him or her as she or he gets ready for the job?
Maybe two bits of advice. One is appreciate both the reach and the limits and the importance of the position. That in my experience, and this includes being on the outside of OGC and at times being in conflict with the Office of General Counsel as a client or kind of as a competitor entity, either at the Justice Department or in the Office of Enforcement and Compliance Assurance. And also just observing relationships between the OGC staff offices and the client offices, is what seemed to work and didn't work. What worked best is when OGC operated within the lane that's prescribed for it, which is being the voice of for legal interpretation, legal direction for the agency, and being very, very clear when the advice that we were rendering was in the nature of policy advice as opposed to being about legal risk. And where OGC at times has had difficulty in the past with other organizations, or where OGC staff has had trouble with clients, is when that articulation becomes fuzzy, and when clients get the sense that what they're really getting is policy advice that's dressed up as legal risk because the OGC lawyer likes the policy outcome better. That's a trap, a snare that can be avoided. It actually can be fairly easily avoided just by careful labeling. Right now I'm talking to you about legal risk. I do have some views about the policy dimensions of this that I'd like to share as well. They're not about legal risk, but they may be about reputation and other things that are worth noting that I see. And I share them with you because I see them and feel like it would be a service to do that. The other thing is to take advantage of the assets that are available to you. The Office of General Counsel at EPA, in my view, is one of the strongest legal teams in the federal government. Its strength is partly presented by the fact that people care about the issues that they're working on. But it also has a fabulous reputation, has the ability to draw people from the very best schools. And in my experience, EPA, OGC, and some of the elements at the Department of Justice are the best places, the places where you'll find the best lawyers. And it is, in my view, a profound mistake to not avail oneself fully of the capacity that's presented by that, and to separate oneself from that capacity. It greatly limits your ability to get the work done. For the most part, even though people care about the work, they care more about being good lawyers, and also understand as careerists that they're there to implement or effectuate the agenda of the democratically elected presiding administration. They're not to be feared. They're able to help you get your job done. And the folks who do well in the job and perform the job the way that it should be performed are ones that appreciate that.
I always would say that when I needed to know something about a Supreme Court case, any major environmental Supreme Court case, I didn't need to call anybody. I just needed to walk down the hall. And that amount of talent and experience just does not exist anywhere else. And so I would agree that the best resource.
Except at your law firm, I'm sure.
My law firm is a close second, for sure. But
it's different, though.
It is.
It's different. You've got the premier experts in the land on pretty much every subject on EPA's books at your ready disposal, and that's something that you and I and others who've been in that position will always miss. Yes. Ultimately, it's really not replicable anywhere else.
That's correct. For our last question, we're doing this podcast series as part of the lead up to EPA's 50th anniversary, which will be in December of 2020. When you look forward at the next 50 years in front of EPA, what do you see?
Well, for me, it's an interesting question because we're just coming off this is the 50th anniversary of ELI. I guess technically our birthday is December 22nd of this year. But our entire year of programming has been both looking at the past, but also trying to figure out how to build on the past to secure the future. So the last 2 days, I was out at Airlie House in Virginia for a program with GW Law and ELI called Reimagining Environmental Law that was trying to contend with where we need to go, what is the unfinished work relative to environment, and how do we get there. And as you might imagine, to have a successful conversation like that, you almost have to look beyond current political dynamics. Otherwise, you end up so constrained by what is practically deliverable that the big ideas can elude you. On the other hand, if you liberate yourself to think about the big ideas, then you may end up with an altogether impractical agenda. So we're going to be sifting and sorting that and trying to articulate some notions around it that we hope can be helpful and, in the ELI tradition, apolitical. But maybe just to foreshadow a couple of things that came up in that conference that I think will be important for EPA as the country's environmental leader to contend with is whether there's a different path to travel on ecosystem protection and degradation avoidance. And an interesting idea that we discussed there that I think we'll end up trying to give some framing to is the notion of building on the no net loss objective that we've had for wetlands since around 1990, I think, in the George Bush Senior administration, and frame that up in the ecosystems context, where we try to articulate and make real a node net loss and ecosystem function notion that will enliven our sense of how we should be thinking about land uses, upstream, downstream responsibilities, and fill out kind of a more holistic approach to protection schemes that are really aimed at making sure that we don't suffer further reductions in the capacity of natural systems, which is a big issue, big problem right now. We'll probably find ourselves talking about the pursuit of a lower carbon society and how to think about procedural statutes like NEPA and the Endangered Species Act that have contributed greatly to environmental quality in this country, but are surfacing as barriers of sorts to rapid build out of solar and wind energy. How should we be thinking about that as environmental lawyers? And the national leadership on the environment at EPA will need to have a voice on those questions as well. We talked a lot about the private sector and sustainability commitments in the private sector and what we call private environmental governance as a kind of a parallel opportunity for impact and influence, and how that can be optimized and how that should influence the governmental role, or how government can help catalyze that so it can be everything that it might be. We also talked about environmental big data, and this will be hugely impactful for the agency in terms of how to relate to a world where we're going to have much more granular and real-time information about environmental conditions of every sort and form in a way that will outpace the traditional government intervention strategies and communication strategies. And it'll be a real challenge for EPA not to be flat-footed in the machine era in response to this kind of information. So what we really need from the EPA of the future, the Office of General Counsel as an important part of that architecture, is the capacity to think the big thoughts about where we go from here, and to help lead the country in the direction of those thoughts. And hopefully that leadership is more than just saying, well, this tool or that tool can't be used to this effect. If we think it's an important issue, then we ought to be saying what the tools are that should be brought forward to deal with these questions. Not, we just can't do anything about it. That's not what I've understood to be the Environmental Protection Agency. And my hope is that the leaders of the agency now and in the future will see their role in that way.
Well, Scott, thank you. It's been my pleasure to get caught back up with you and hear some of your thoughts about the past, but also about the future. I want to say happy anniversary for your 50th anniversary of ELI, and thank you for the support for this podcast series and the team that you have here at ELI who's made that possible. So thanks for talking with us today.
Sure thing, Kevin. My pleasure. Thanks for doing this.
Thank you for tuning in to People, Places, Planet Pod, brought to you by the Environmental Law Institute. We would like to hear from you, so please send us your questions, comments, and ideas to podcast@eli.org. And if you're interested in learning more about our work, attending one of our events, reading our publications, or becoming a member, please visit our website at www.eli.org.